For more, we're joined by SABC News senior reporter Canny Maphanga. Canny, good afternoon. Another busy day in the Electoral Court. We understand that 5 political parties are there on an urgent basis, among them being Arise Mzansi as well as Operation Dudula. Talk us through some of the arguments they've put forward today.
Well, indeed, good afternoon to you, Mfunda, and to the viewers at home. Well, just to give you the full list of the political parties that have actually hauled the IEC to the Electoral Court, it's Arise SA, Operation Dudula, the Cape Independent Party, the Defenders of the People, and the Independent South African National Civic Organization. So we understand that the crux of most of these issues is the failure to meet that Section 27 requirement, which was part of the March 8th deadline to submit those lists. Now, to give you the synopsis of the 3 lists that were needed on the March 8th deadline that we saw pass. You needed the national candidate list, which features political parties only, contesting for seats in the National Assembly. Remember, in the National Assembly, you have 400 seats, 200 compensatory, 200 regional. So the compensatory would be the national seats. Then there's also the national regional candidate list, which is the list of candidates that feature political parties and independent candidates. Remember, after that ruling by the Constitutional Court, the independent candidates have been featured, but in the 200 seats of the 400 that will sit in the regional category. Then there's, of course, the provincial candidate list, which is for the provincial legislatures. Most contenders have not been confused by the provincial part.
Yes.
It is the national regional candidate list and the national, which has presented some challenges for political parties that want to contest the May elections, especially those new political entrants, because it seems that a lot have not understood that you can't contest the national without also submitting that regional ballot. So if you look at Arise South Africa's case, you may remember at the time that they thought they were on that list. They appeared on that list, the national list, and then there was a bit of a few days where we saw that they were off.
Yes.
And there was a protest that followed.
And this is what Dali Mpofu, the
that's what
legal
he's
counsel, was
of.
actually speaking about.
And then when the IEC clarifies the issue for them, it's characterized as an administrative error and that they weren't supposed to be on there. Now, the IEC's version is that they didn't receive those candidate lists that we speak of, which you need in order to contest that national ballot. They don't have it. And of course, if they don't have it, you wouldn't have gotten that email notification to say you've submitted or you didn't, or whatever the case is. So the Arise South Africa is saying they understand that argument that perhaps they didn't receive it. They're arguing that they did submit it. Paul Degata under oath is stating in his affidavit that he did receive it.
So they understood what they needed to do insofar as the regional to national is concerned.
Well, that's not necessarily the argument. They're stating that they submitted the list. Whether it was received or not is the dispute on the IEC side. But they're saying we accept if you didn't receive it. We are saying under oath, and the leader is saying under oath, rather, that they submitted those lists. So on that argument alone, they're stating that they want to be reinstated, or in the alternative, be given the opportunity to comply with Section 27. That means they want an order from the Electoral Court to at least give them 2 days to comply with what would be needed. Now, you know that if they're given that order, then that process must follow that you must give the opportunity for objections, like you've seen in the process going so far, and then that process can be finalized if they're compliant with Section 27. So essentially what has happened here is that they've argued that on the deadline, they on their side submitted it. It's a statement made under oath by Paul Degata, but the IEC is saying that they don't have anything on their system to show that such happened.
Now, Canny, onus is upon them to prove that indeed they actually submitted on time.
Yes.
When listening to the arguments, did you get a sense that they had some sort of proof? Was there logging of calls to say we're struggling, we're currently busy, as what we've seen with the other people that brought their matters before the court? They would have stated we logged 8 calls, we were struggling. Eventually, we tried to update. Have they taken the court through any of that? Well,
a sworn affidavit is a form of evidence to state that this is what we did. I mean, you cannot lie under oath. They've presented to the court what they did, what their process was, and they've said to the court, we accept if the IEC didn't receive anything on their side, but we have submitted something. Now, that brings me to Operation Dudula, because their scenario speaks to what you're speaking of, Mfundo. What they say they've done is that in the minutes leading up to that 5 p.m. deadline, they were on the website trying to submit and received a technical error. I think it was short of a few minutes to the deadline closing, where they alleged that they reached out to the IEC for assistance and didn't get that assistance. What they then did was email those lists to the IEC to upload for them. They've argued that that alone is them meeting that obligation and that duty to submit their lists, and the technical area was beyond their control, and that they should be given that opportunity to comply and to contest those elections. They've also highlighted both political parties, Section 28, subsection 1, which gives a statutory obligation to the IEC that where you don't meet compliance, they have to inform you and give you an idea of where you've had those defects so that you have that opportunity to comply. Because what you could result in is that you may disenfranchise some voters who wish to place their right to vote on these particular political parties that have been disqualified for failing to meet Section 27 of the Electoral Act. So those are the cases that we're hearing, minor disputes. However, they are significant because they do bar you from contesting those elections. We know that that's going to be a watershed moment, a very important election, and all the new entrants want a chance to join the race. We'll have to see from the Electoral Court on whether they do overturn those decisions or not by the IEC to disqualify these political parties for failing to meet some of those statutory requirements in order for you to contest.
Well, Canny, we trust you to monitor those proceedings carefully for us. That's SABC News senior reporter Canny Maphanga speaking to us.